Shama ma'am has already explained as to what the IPR profession looks like. I will run you through what a day in an IPR professional's life looks like, so that if you really want to pursue this as a career, you can know these things before you hop into this. I work with trademarks specifically to provide more credibility towards the kind of work I do. I have worked with conglomerates such as Whirlpool, such as Royal Enfield, and pharmaceutical companies such as Merck Sharp and Dome. So these are big names which are there in the market, which you see hoardings of, which you see boards of. And when you go ahead and evaluate the amount of money which each of these trademarks have within them, it will run in millions and billions of dollars. That's the amount of money they spend towards maintaining their brand. That's the amount of money companies spend towards preserving their brand. Now, as people who are teaching management, who are studying management, as individuals who may have a startup of your own in future, here are a few things which would be really helpful for you to keep in mind when you are setting up your own startup, or when you are advising your company on how to preserve their IPR better. As it has already been said before, clearance is the first and the most important step towards preserving your rights in the mark that you create. At the very initial stage, when you are creating a firm of your own, or when you're advising an entity which is now going to commence business, make sure that clearances are thorough. Now, India has great infrastructure, to be honest, with respect to conducting searches. There are also other tools which entities like WIPO have provided individuals to. These are free access tools. In India, there is ipgov.in, which helps you search whether a trademark exists or not in the respective class of goods that you are trying to seek protection for. There is the Madrid Monitor, which helps you track applications which have been filed in the name of a certain brand or a certain entity under the Madrid Convention. The Madrid Convention is a very simple way of filing an application. You file an application in one country and you designate several other countries. This has been mentioned by ma'am before. Now, Madrid Monitor helps you track that. There is tmview.com, which helps you track brands which have attained registration in almost all countries which are designated with WIPO. There's also the WIPO Global Brand Database, which has all data about trademarks which have been filed, which have been registered. So these tools and these infrastructure will help you a lot in conducting the search for whether or not the brand you have come up with, whether or not the mark you have come up with is unique, is something that warrants registration. Now, there are multiple types of marks which you can get registration for. There is the word mark. Examples of word mark would be any trade name or any brand which is being registered. As ma'am was mentioning earlier, trade name is different than trademark, but a trade name can get the same benefits of a trademark upon registration or even without registration. Now, these trade names, while you cannot have monopoly over surnames, etc., but if your trade name is something unique like Whirlpool, your trade name also gets protection. Now, the other kinds of trademarks are device marks, which are the logos. If you look at a half-bitten apple, you will know that it's Apple Inc. You will know that it's meant for iPhone, iPad, etc. If you look at a swirl, you will know that it's a Whirlpool device. If you look at a Jaguar animal, you will know that it's the Jaguar car brand. So that's how these device marks have exclusive association with the proprietor who has registered the mark or who uses the mark. So this is also a type of trademark which you can register. There are other non-conventional marks such as motion mark. The two hands connecting at the beginning of a Nokia ad, or when you switch on your Nokia phone, there are two hands connecting and it says connecting people. That motion mark is also registered. There is sound mark. The Whirlpool jingle that you hear at the end of every commercial is also registered as a trademark. There are color marks. The Tiffany blue or the red color Christian Louboutin shoes that you get are also registered as colored marks. There is the concept of smell marks, which is very interesting. A certain smell is being registered as a trademark and is being attributed to one entity. So these are different kinds of trademarks which can be registered. There's also shape marks. The unique shape of the Coca-Cola bottle is something that has been registered and granted protection. There is no other entity in the world who can provide soft drinks in a bottle that is similar to the Coca-Cola bottle. So these are different ways through which you can register your trademark. Now, after conducting the clearance, there's one very helpful tool for startups specifically is to get a MSME certificate. An MSME certificate has 3 criteria. If you're a micro firm with investment of rupees less than 1 crore and a turnover of less than rupees 5 crore, you're a micro entity and you can avail the certificate. If you're a small entity with investment less than 10 crore and turnover less than 50 crore, you can be entitled as a micro entity. For a medium entity, the criteria is less than 50 crore investment and less than 250 crore turnover. The benefit of having such a certificate of MSME is that you get discounts on or rebates on applying the trademark or applying the patent even. There is a huge dearth of trademark protection because some people are not able to afford it because small startups don't want to invest a lot of money in it. The tools which I mentioned earlier are very easy accessible tools which startups can actually do it themselves without having to hire an attorney. This is actually something that a trademark agent can also do. User claim is one of the most important aspects of a trademark application because India is a country which follows the first use principle, which means that tomorrow if I file an application for any brand such as say Apple, I will not be granted that registration because Apple has been used by somebody else before. That's what the first use principle means. Now, to make sure that your brand later is not being used by somebody else, is not being applied for by somebody else, it is very important that you record dates on which you use it for the first time. These recording of evidences can look like an incorporation certificate. So Whirlpool India Private Limited was incorporated, I think, in 1956 or sometime earlier. That incorporation certificate is an evidence that, oh, Whirlpool was used in India for the first time at that date. Alternatively, if you're not an incorporated entity, a startup does not necessarily have to be incorporated. It could be a partnership also, it could be a single person firm also. So if your small business essentially is not incorporated, alternative means of use can be tracked back to social media. If you're using the brand on your social media, these days it's become so accessible for anybody to market their products on social media. That also entails as use. So recording a date as early as possible of use of your mark will help you to get a registration easier, because the trademark office also wants to check whether this mark has been used as of this date or not. So alternative means again would look like invoices, would look like packaging where the mark has been used, would look like newspaper advertisements, etc. It's very important to preserve these documents. It's very important to preserve the date on which the document was first created. All of this evidence will help you get a registration much easier, because these days the current trend that we've seen is that the trademark officer who will examine your application is actually scrutinizing your application in detail. So one quick anecdote, there is a trademark registration for the number 1 dating back to 1980s. Now it's very funny how anybody can try to monopolize the number 1. The number 1 is a common word, is a common number. Anybody should be able to use it. But the fact that the trademark office granted registration for this application is slightly absurd, right? So our Department of Department of Trade and in the trademark office has been taking note of all of these things that have happened in the past, has been making sure that our infrastructure is better, that examination of applications happens better. So this industry in general is developing, which means that we also as applicants have to make sure that we do the things correctly. So all of this evidence will help convince the trademark officer so much better. will help convince the examiner so much better such that the application process is smooth. So if you're a small business, if you're a startup, make sure that you document all of these evidences very carefully. Now, quickly coming to the enforcement aspect, when you have, even if you do not have a registration and you have been using a certain trademark in the past and you have continued use of it, even if you do not have a registration, based on good faith, based on bona fide use, you can seek enforcement action. It is not necessary that enforcement can only happen through registration. There's this principle of passing off in intellectual property. Passing off means that somebody else is pretending to be me. If a certain trademark is associated exclusively to me, somebody else shouldn't pretend that they are me or they're affiliated with me and use the similar trademark. So even if your mark is not registered, you can always seek enforcement action as the bona fide user, as the bona fide first user of the mark. So some enforcement actions look like sending a legal notice, procuring out-of-court settlements through arbitration, negotiation, conciliation, or through domain name disputes. It is not necessary that you have to go to court, that you have to extensively go through those proceedings. You can always settle outside of court, you can always send legal notice, you can always get enforcement actions. There are ways to cancel somebody's registration, there are ways to oppose somebody's registration. There are multiple recourses which the statute provides us before us having to go to the court. Now what's very interesting is that because these days all of our operations are mostly online, a lot of small businesses do not want to invest in physical infrastructure but rather invest in online infrastructure. They have websites, they have e-commerce websites, they operate from like a small they operate from a small unit and they connect with their customers online. They conduct their trade online. Because a lot of things are now happening online, domain names are something which are also being infringed by a lot of people. So you will find cyber squatters who will register a domain. A domain name is basically the URL of a website. There will be people who will register the domain name, not use the domain name, and then offer to sell the domain name to the right holder at a much higher price. Now this becomes problematic. This is the practice of cyber squatting. So if tomorrow, if I make I get a domain name registration for Samsung.in, although Samsung.in exists, but if I say get registration for SamsungIndia.in, and I don't use that page bona fidely because I'm not the right holder of Samsung. Now, if Samsung has to get rights into that domain name again, because operations online means that URLs are very important. If I open on SamsungIndia.in and if I see a wonky page, I would assume Samsung is not doing its job correctly. Which is why domain name disputes are also very important. There is an entity called NIXI, NIXI, National Internet Exchange of India. Now NIXI helps individuals file such complaints. If you go to the NIXI's portal, you will find a pro forma complaint draft, which you can fill it yourself. That's how easy the process is. Although the prices are a little high of the fees for conducting such a domain name dispute, but it is so much more cheaper and so much less time consuming than an infringement suit in a court. So there is also WIPO's UDRP mechanism, which also offers a pro forma complaint which you can fill up yourself, and there will be arbitration sessions such that the domain name is returned to you. So there are multiple ways through which you can settle outside of court, which you can get your rights back into the matter outside of court. And these are things that you can do it yourself without a law degree if you peruse these statutes or if you just skim through the rules. I don't mean to say that the job that I do is extremely easy, because it's not. There is a lot that I have to put into while drafting certain documents, while ensuring that the arguments that I'm making for my client is correct. The arguments that I'm making for my client is such that the client's rights will be brought back to them. That's where a law degree really helps. That's where my practice becomes relevant. But at least when it comes to trying to preserve your trademark your trademark rights or your intellectual property rights, be it copyright or patent as well. It's very important that on your part you're able to do these small things such as clearance searches, recordal of evidences, enforcement actions such as watch monitoring, like hiring watch monitor services or keeping an eye out on the trademark journals yourself. All of these smaller things, I think small businesses can easily do themselves. It's only when it comes to the legal aspect of it is when you need an attorney. Otherwise, it's super easy when it comes to the online tools that we have these days. I would like to emphasize on the fact that it's always good to get some legal advice while drafting your applications for patents, because most of the time patent applications get rejected because they are not drafted correctly. You should be able to convince the officer in the application itself that your idea is novel. As it was mentioned earlier, that there exist portals, there exist online websites through which you can search whether an innovation has already been asked for protection or not. I would beg to differ from the previous speaker. India has good infrastructure to conduct such searches. We should conduct such searches before filing such applications. We should get legal assistance while drafting such applications, such that our innovations are protected at best. I would be happy to take any in-person questions. I'll stay back for a little longer. Yes?
Full form of NIXI again?
NIXI, National Internet Exchange of India. If you have any questions regarding how the operations of the procedure of intellectual property works, I'd be happy to.
Hello?
Yes. Somebody has their hand raised.
With the increase in open source platforms, how means IPR is impacted?
Sorry?
With the increasing open source platforms, how IPR is getting impacted?
By open source platforms, I assume you're talking about these clearances websites, right? Right. So IPR is not getting impacted in a bad manner. What happens is, because there are registrations of individuals recorded on these websites, an individual like me who has, say, certain rights in a mark can check whether somebody else has applied for my mark or whether my mark was registered by somebody else before me. If that is the case, then I will have to change my mark. If after getting the registration for a mark, somebody else is using the mark subsequent to me or applying for the mark subsequent to me, then I should be able to check on these open source websites such that I am able to initiate enforcement action against them. As ma'am had earlier said, that the trademarks are published on the journal. There is an opposition period in which, in those 4 months, attorneys like us check whether marks similar to that of our clients have been applied for. If yes, then we file an notice of opposition against them. So this is how these open source websites help us in tracking what the applications are, what the registrations are. In case your question, however, is concerned with open source code in terms of programming, open source code is not copyrightable. Open source code is in public domain, which anybody can use and which anybody can tweak according to their necessities and then create their applications or websites. It is only if you have created a computer code from the beginning, from the scratch, if you have coded it yourself, that's when you have a copyright in it. And you can always, I think, click Ctrl-U and look at the source of a website and check whether it's copying your code. Otherwise, most websites and applications these days are based off of open source codes. It's only when you create it yourself is when you have copyright. Again, you don't need registration for it. You just need to claim prior use because India is a first use country. Alternatively, in US, you can always apply for a patent in computer codes. India doesn't allow that. US does. So in case you plan on launching a website or an application specific to US or in US, you can always get a patent registration for that as well.
Next question.
Yes.
What is the procedure of filing a copyright and what is its costing?
Okay. The costing, I think you can check on the government's portal for copyright. I don't remember at the back of my hand, but the procedure of getting a copyright registration is as simple as getting a trademark registration. However, in a copyright proceeding, you do not have an opposition the way you have it in trademarks. So for copyright, you file an application, you present your whatever work that you have. It could be an artistic work, literary work, a video recording of a dramatic work. Either way, when you file this application and when you mention XYZ details of your application, the registrar will then peruse it, will then conduct a search on their own in whatever database that they have. If they do not have any objection towards the application that you have submitted, they will provide you with a diary number. If a hearing is necessary, a hearing will be scheduled such that you convince them that it is an original work which can be copyrighted, and after that you get a copyright certificate. Now, what's super interesting is that copyright does not require a prior registration. You can always claim copyright in a work without a registration because the statute does not mandate. The statute doesn't say that to enforce rights you need to get registration, which is why more often than not people don't get copyright registration, as opposed to recording the date of first time that they used or the first time that they created something. Which is why, as I mentioned earlier, evidence gathering, like safeguarding your evidence is super important in trying to take claims. Thank you so much for providing me with this opportunity.